Hey, I'm Beau. I'm an attorney. I've been practicing in personal injury for the last 10 years, both on the plaintiff side and the defense side. What I'm hoping to do is provide a unique perspective to personal injury law and provide some education materials both to consumers and potential clients so that they can make better decisions. So this is our fourth recording, I think. Is that right? Third recording. Feels like the fourth. I don't necessarily enjoy this advertising social media stuff, but be it as it may, it's what we got to do, so we're doing it. What I want to talk about today is, at least one of the things I want to talk about today is our litigation philosophy. What drives us? Why do we do what we do, and how do we go about doing it? I listen to a lot of self-help gurus. You see them on LinkedIn and all these different things, and they're all selling the secret sauce. They're all talking about, hey, how are you successful? How are you successful? These are the things you need to do. And I mean, I don't seek these guys out. They just pop up on my feed. Sometimes they're interesting. Sometimes they're funny. So I'll pay attention to them for a little bit. But in my mind, it all comes down to this. And I thought about this a little bit this morning. It is consistent, concentrated effort, sometimes sacrificial, over an extended period of time that yields good results. I think it's as simple as that. If you're consistent, meaning that you come to work every single day, and you're intentional in what you do, meaning you have a plan and you execute that plan, and when necessary, sacrificial, meaning that you'll stay the extra time or do the extra things you need to do, and you do that day in, day out for weeks, months, years, whatever it may be, I don't see how you cannot be successful. So when we take a case, when we become involved in a case, it's not just a business transaction at that point. It's a responsibility. I like to think, and in my mind I do, take personal responsibility for all the things that go on in my office. When a client comes and hires us, I hope that client is put at ease. I hope that burden is lifted off them and put onto us. That's how it should be. The client shouldn't go home worrying about the case. The client shouldn't continue worrying about all the things going on with it, because they should know that we've got it and we're bearing it and we're seeing it through. They should know that we're going to do everything that is necessary and everything that's possible to make sure the client gets a positive outcome. We're going to consistently, intentionally, and if necessary, sacrificially exert effort on that case for as long as it takes so that the client can be successful, so that the client can get the best outcome possible. We've also talked a lot about how do you go about picking a lawyer? How do you do this? How do you do that? How do you navigate this web of information that you get when trying to find an attorney? And one point came to me this week. I defend a lot of cases, and we also prosecute a lot of cases. And I get this case that comes across my desk, and I'm just like, what on earth was this person thinking when they took this case? And it dawned on me, they take every single case that walks in the door. This particular law firm, and there are multiple law firms that do this, especially the big box law firms. Every single case that walks in that door, they take it. I want to add something to our list of things that you should ask your attorney when you sit down with them to interview them. How many cases have you turned away in the last week? How many cases have you turned away in the last month? Because if the attorney has taken everything that walks in that door, one of two things is true. Either the attorney is desperate, meaning that they don't have enough work, and if they don't have enough work and they're not just starting out, that should be a red flag. Or they're taking everything that walks in the door because they're greedy. They want to have their hand in every single case they could possibly get it into. People, and especially other attorneys, judge attorneys, right or wrong, it's true, by the cases they become involved in. I remember early on in my practice, I was still working for someone else, and an older lawyer told me, The most powerful tool you have in your arsenal to guide your practice is the ability to say no. To say no. If you don't feel like the case is something you should become involved in, say no. Say no up front. If you feel the case is questionable, meaning you're willing to take a look at it, but you're not 100%, tell the prospective client that. Tell them, hey, I will take a look at this, I will do some initial investigation, and I will get back with you about whether or not we'll actually pursue this case. Don't just sign them up and then cut them loose later. That's something that I do regularly. If someone comes to me and their story's just not adding up, or there's more information that I need that they can't provide me, I'll tell the client, hey, give me 2 weeks. Let me make a couple calls. Let me make a couple requests. I'll get some initial information, and then I'll get back with you and tell you whether or not we can continue in the case. And if we can't continue in the case, I'll give you all the reasons why we can't. I'll give you that information so that you can make a decision. You can say, hey, I no longer want to pursue this, or you can take it to another attorney. All right, so what is a deposition? Let's talk about that. A deposition is simply an interview under oath. That's all it is. I tell clients the same thing every time. You're going to come to my office. You're going to go to someone else's office. You're going to sit down in a conference room. I'll be next to you. There'll be an opposing counsel on the other side and a court reporter at a minimum. You'll be placed under oath and asked a series of questions. Some clients, this does not intimidate them. Some of them get nervous as they can be. But there's no reason to. There's absolutely no reason to. Because the day prior to the deposition, in fact, I'm going to prep somebody for a deposition later on this afternoon. I'm going to sit down with you and we're going to talk about the case. We're going to talk about the issues in the case, and we're going to talk about the proper ways to answer questions. I tell every client the same thing. Always tell the truth. I'm never going to ask a client to skirt the truth or lie. And in fact, if I know for a fact that a client is lying, we've got serious problems. Me and the client are going to have a discussion about my continued participation in the case. There are essentially 3 ways to answer a question at a deposition. Yes, no, I don't know. 90% of the time, one of those 3 things should be the first thing that comes out of your mouth. Now, obviously, if an attorney asks you what your address is or how many kids you have, you can't answer that yes, no. But when you start talking about the actual case, the medical treatment, things of that nature, yes, no, I don't know, I don't remember. So let's talk about the proper usage of those 3 answers. If a question can be answered yes or no, answer it yes or no. After that, if you want to explain your answer, explain your answer. However, I encourage clients to keep it to about 3 sentences tops. You only have to answer the question posed. You don't have to offer up additional information. When I'm taking a deposition, one of my objectives is to get the person I'm deposing talking. Get them talking about their kids, get them talking about their work, get them talking about their church. Build a rapport with that person. Joke with them, cut up with them, be a person. That's twofold. One, I want to make them comfortable because I'm honestly there to get truthful information. But 2, I want them to feel comfortable telling me what they want to tell me. So they get asked a very simple question, and instead of just yes, no, they go on a 2-page explanation of anything and everything you could imagine. When they stray outside of the question, all they're doing is giving me additional information for follow-up questions, and the deposition goes longer. If a client or a person being deposed just answers yes, no, I don't know, it's going to be a very short deposition. If you get put in a position where yes or no doesn't exactly fit and explanation is required, keep that explanation to a minimum. The other answer, I don't know. This is sometimes the best and sometimes the worst answer you could ever give. If a person truly does not know the answer to the question, or they would have to guess or speculate to come up with an answer, and a perfect example would be, how much distance was there between point A and B at any given time. Whether it be an accident or a shooting or whatever it may be. How much distance was between? Well, you don't have a ruler or a range finder with you everywhere you go. You don't know if it was 10 feet, 20 feet, 50 feet. You can't be exact. So when you're asked questions like that, it's perfectly reasonable to say, I don't know, because you weren't measuring it at the time. However, if you're asked what parts of your body hurt as a result of this incident, the answer better not be, I don't know. There are things that you're expected to know. I've had this happen. I've had clients go into, I just call it the I don't know syndrome, where they're just so nervous. I don't understand why. And literally they'll go for 20, 30 minutes saying, I don't know, to every question. Opposing counsel is not going to push them when they say, I don't know. And they like that. The client feels good. Oh, I answered the question. I said, I don't know. They left me alone. So the client just keeps saying, I don't know, I don't know, I don't know. All the while I'm sitting there next to him just dying inside. When a person says, I don't know in response to a question they should know the answer to, they lose all credibility. They lose all credibility. So don't abuse I don't know, but use it in the proper context, in the proper situation. And over the years, my depo prep has gotten more focused on the I don't know, simply because I want to avoid that situation where a client gets a case of the I don't knows. They can't even remember their name sometimes. When you're deposed, there's really two things going on. One, you're given questions. That part is obvious. But a secondary purpose of a deposition is to gauge a person. You want to gauge what kind of witness that person is going to make in a trial. How is this person going to present to a jury? I have seen witnesses that are not the best at telling their story. What they say really doesn't seem to make sense, but they're just such nice people. They're just such nice people, and they present so well that it really doesn't matter what they say. I hate to say that. There are those type witnesses out there, and if someone else is that type of witness, I want to know that before I go into trial. So I want to sit down with them and ask them those questions and gauge, to the best of my ability, within an hour or two, what kind of person they are. On the flip side of that, I have seen witnesses that are, they got an answer to everything, and the answers make sense. They're highly technical, highly analytical. They can tell you everything in excruciating detail that's asked, but they just don't connect. They just don't connect to a jury. They just don't have those interpersonal skills. Their mannerisms are odd, or they have no mannerisms, or they're monologued. If a witness is going to present like that, you need to know it. And the only way to know that is to actually sit in the deposition, because it's not going to come through on the transcript. The transcript is very cold, question, answer, written text. There are video depositions that you can take a video deposition, and sometimes those are good tools, but I principally use those for opposing witnesses. I don't take a video deposition of my own client very often, just because they're so final. So be careful how you answer questions. Don't be nervous about a deposition. It's nothing to be nervous about. Be mindful of how you present. And perhaps even more importantly, understand that the person with the power at a deposition table is the person being asked questions. Think of it this way. You don't have to be scared of any question that comes out. You don't have to. All you have to be mindful of are your answers. The person asking the question is more or less someone playing an instrument. If it's a keyboard, they're striking the keys. The person being deposed is the keyboard itself that puts out the result. As a deponent, you're powerful because You don't have to agree with everything the attorney asks you. You don't have to answer questions specifically in the manner that the lawyer asks you to. If the lawyer asks you for a yes, no, then you need to give a yes, no, but you can explain. So understand that even though the attorney may be intimidating, even though it may be an intimidating process that you're uncomfortable with, I could imagine, if you've never been involved in this, it could be very intimidating. But understand that the person answering the questions is the person with the most power in the room, and don't forget that. I was asked a question about a deposition in a movie. I've not seen that movie, so I can't speak to it specifically, but I will kind of give you the parameters of a deposition, like what's realistic. Depositions are not like trial. At trial, the rules of evidence apply, meaning there are limits. There are certain questions that can't be asked. Classic one is hearsay. What did Miss Smith say? You're asking Mr. Smith what Miss Jones said, and Miss Jones is not in the courtroom and not going to appear. You can't ask that question. Miss Smith wrote a letter, you bring it to court, but Miss Smith is not there in court. Well, she's not subject to cross-examination, therefore you can't use that letter. It's hearsay. That's one simple rule of evidence. In depositions, the rules of evidence do not apply. The scope of a discovery deposition is about as broad as you could think of. There are really only two limits to the questions that can be asked. One, and I'm talking specifically about Georgia here. I can't speak to every jurisdiction, but specifically with Georgia. One question that cannot be asked, you cannot get into privileged matters. You can't ask a deponent what their lawyer told them, all right? Simply because they told their lawyer something, that doesn't make it off limits. I mean, if they told their lawyer, if Mr. Smith told his lawyer, hey, the light was red, or hey, the guy who shot me threatened me a day prior, or hey, I was partially at fault for this incident. The simple fact that Mr. Smith told his lawyer that does not make it off limits. You just can't ask Mr. Smith if he told his lawyer that. Another limit that we have in Georgia is you can't ask questions simply to embarrass a deponent. An example would be, if we have a personal injury matter, I'm asking a deponent about their marriage, like intimate details about their marriage. Clearly that has no bearing, and I'm just asking that question to upset them. I can't do that. As long as the question is, I think the word is reasonably calculated to lead to the discovery of admissible evidence, that's the standard. As long as it's in that boundary, I can ask the question. So most depositions, you're going to have 4, maybe 5 people in the room, and you're going to have, I don't know, I've seen people take depositions with no exhibits whatsoever. They just ask questions. They don't put any paper in front of them, no photographs, nothing like that. And then I've taken depositions where I literally have thousands of pages of documents with me, and I may not use them all, but I have them all there if necessary. About 10 months after I passed the bar, I left the firm that I was at, and during that time, I had been primarily working on one case. It was a franchise dispute involving a couple $1 million claim, and I had developed a really good relationship with the client because I was their point of contact. I had no intention of poaching that client or taking that client with me when I left. However, I did feel a sense of responsibility to that client to at least call them, explain to them the decision that I had made, and explain to them that I was no longer going to be involved in that case. Well, much to my surprise, the client literally asked, how do we fix this? I was like, what do you mean? How do you fix this? Well, how do we fix this? Meaning, how do you keep the case? So I kept the case. Truthfully, did I have a lot of business with that case by myself at that point in time? If you'd asked me in that moment, I'd say yes. Looking back 10 years later, probably not. But I worked on it a lot. The client got a good result. But getting back to the deposition, the first deposition I took was called a 30B6. It's a corporate deposition in federal court of a probably about, I don't know, probably $50-60 million company. That was my first deposition. And you talk about paranoid. I bet I prepared for that deposition for 3 weeks, at least 3 weeks. Staying up at the office till 2 in the morning, scared to death I was going to do something wrong, and trying to make sure that that I did everything right. Well, as you can imagine, in a dispute like this, there's a lot of documents. Well, I printed out the entire record. So I had this oversized Adidas bag, and it's like the ones you put football pads in and things like that. It's huge. I mean, it's literally probably 4 foot long and 2.5 feet wide. And I got this thing stuffed with notebooks. This thing weighs 100+ pounds. It has to. And I've got to fly to take this deposition. And I'm not checking this bag. Like, this has all the documents in it. I'm not checking this bag. So here I am running through the airport with my briefcase and a duffel bag full of paper. I printed everything out because I wouldn't have a printer when I got there. And I'm running through there, and I've got, I don't know how many thousand pages we had. I really don't. But taking that to the deposition, I don't do that anymore. I learned that, there are going to be some key documents in every single case, whether it be a contract, a picture, or whatever, and I take the time in advance to identify what I want to talk about and make sure that those exhibits are properly marked and ready to go. And usually I can get it down to one notebook. I'd say for attorneys in this area that practice in the same field that I do, I'm probably notorious for having more exhibits than most. Some people will have 2 or 3. I typically average maybe a dozen, maybe 20 on a really complex personal injury case. So yeah, there can be a lot of documents. It depends on the case. The time a deposition goes, like how long can the deposition be? Under the statute, you get 1 8-hour block. So you can literally, under the statute, without seeking any sort of extension of time, you can do an 8-hour block. Now, you can get more. You don't have to go to the court to ask, because discovery, which is what depositions fall under, are really within the discretion of the court. So if you give them a reasonable basis for saying, hey, we need more time, typically they're going to give it to you. They're not going to shortchange you on discovery if you can articulate why you need the additional time and it makes sense. So typically an 8-hour block. Now, will that be 8 hours straight? No. Can it be broken up over 2 days? Probably not, unless it's a really complex case. If it's a corporate deposition with multiple deponents, then yeah. I think the movie I was asked about involves a social media company deposition. And if it was a 30B6, a corporate deposition of that company, it could go on for months. You could have, multiple people within that corporation coming to be deposed. And it could go on forever. It could go on for a long time, really long time. But just in a party deposition, not a corporate party, typically you can get it done in I don't know, 1 to 3 hours. I think if it goes over that, you're one or two things is happening. Either you've got a really evasive witness, you've got an attorney who's just asking questions to run up a bill, or there's just some disconnect. Getting back to that evasive witness thing, don't be an evasive witness. Some people think they're scoring points by being evasive. I'm not going to give that lawyer what he wants or what she wants. I'm going to, answer the question. I'm not going to answer the question. I'm going to, just go off on a tangent. A good attorney is going to listen to your answer, and they're going to know whether or not it actually answers the question. Some lawyers don't. Some lawyers they got a checklist. They ask the question, and whatever you give them is what they get, and they go on. They just keep moving. A good lawyer is going to actually listen to the response, and if it's not responsive, they're going to ask you the question again. And then they're going to ask your counsel to instruct you to answer the question. And if counsel can't get you to do it, at that point in time, they're going to call the judge. If they're going to say, "Hey, I'm objecting to this response as unresponsive to the question. It's a non-responsive answer." And the judge is going to get involved. And if you get the judge involved, the person answering the question's already lost, because the judge is like, "Hey, this person, why am I being bothered with this?" And if you continue to progress in that and being unresponsive, you can be sanctioned to the point where you have to pay for the expenses incurred in the deposition. You can have to pay the opposing party's attorney's fees, and then there's much harsher sanctions out there. You can even have your pleading struck, and by that I mean lose the case outright, simply because you wanted to be cute and not answer questions. So don't be evasive. You're wasting everybody's time. You're wasting your own time. You're just going to look silly. Just answer the question and move on. I got 3 favorite lawyer movies. Every lawyer's got favorite lawyer movies. My Cousin Vinny, love that. A Time to Kill with Matthew McConaughey, and also Lincoln Lawyer, Matthew McConaughey. Matthew McConaughey makes a good TV lawyer. He just does. I don't know why. So I may have dated myself a little bit with those movies, but I'm telling you, they're great movies. They're timeless. You should go watch them if you've not watched them. So why do I like those movies? At the firm I initially started with, it was like we had a movie night, and everybody went and watched My Cousin Vinny. It was playing rerun on some screen in Macon. Joe Pesci in that movie, his lack of experience is clearly evident, and this guy has no clue what he's doing. But he gets to the truth. He actually goes and sits down with people, listens to them, weighs their version of events against the other evidence, and finds the inconsistencies. And then he uses those inconsistencies in court. He shows them. It's a very good example of what a good trial lawyer is going to do. You can't develop your entire case sitting in your office. I can sit up in my office all day, every day, cranking out work, working hard. But unless I go actually talk to people, unless I actually go to the scene where things happen, view the evidence and get out of my office and beat the street, do some groundwork, I'm going to miss out on all that great evidence. It took me a while to figure out what trial lawyers are supposed to do, because in law school you learn the law. You learn legal analysis. Read this case, apply it to these facts, and what happens. What they don't tell you is, in real life, you're not going to get a nice, neat little sheet of paper that tells you all the facts. You're not going to get that. Like, what do you mean? How do I apply the law if I don't know the facts? Your job as a trial lawyer is to get out and find out those facts. What are we going to put into this case? What facts are we going to put in to run it through the legal analysis to yield a result? Joe Pesci does a great job of that in that case. So that's why I like that one. A Time to Kill, just an awesome movie. I mean, if you don't like that movie, something's wrong with you, in my personal opinion. I think it cuts across, it just cuts across all boundaries, all barriers. What I like about that case, about that movie, is that Matthew McConaughey is accused of being obsessed with his case. Matthew McConaughey goes through a lot of turmoil, a lot of problems for the betterment of his client's case. I think that the ability to identify with a client and be a champion for their cause is really shown in that movie. Matthew McConaughey had very little incentive to do what he did in that movie, aside from the fact that it was the right thing to do. Maybe I'm a little bit naive, but from time to time, I do get clients that I feel that way about. From time to time, I'll get clients that I look at them and I just want to hug them. I hate to say it, because sometimes that may not be professional. My lawyer hugged me, but I really want to see them succeed. And the way Matthew McConaughey goes about doing that in that movie really speaks to me. My wife used to get so tired of watching that movie. She would come home, I'd already have it on. It's like a 3.5-hour movie, but if you haven't watched it, it's great. And then lastly, Lincoln Lawyer, another Matthew McConaughey movie. There are things I like about that movie and things that I don't like. And if you've not watched the movie, this might be a spoiler for you. So don't listen to this. You're being warned. I like Matthew McConaughey's approach in that movie, because the way he goes about defending the case is realistic. There's not this Matlock moment where someone jumps up and yells, "I did it," but it's a lot of small, subtle points that he scores over an extended period of time that yields a good result. And why it's realistic is, if it's a lopsided case, like if one side clearly is going to win, why are you at trial? Why isn't that case being resolved? Whether it be a civil case or a criminal case. I mean, if all the facts are against you and you have no hope, why are you there? Why not just accept a settlement and move on? Either side, whether it be defense or prosecution. So when you have these close cases, the best approach, the most conservative approach, and probably the approach that's going to yield the best result, is to subtly score points over an extended period of time. And Matthew McConaughey does that in a very, very skillful way in that movie. What I don't like about it is the witness tampering. There is some witness tampering that goes on. It makes for great TV, great movie. Very, oh goodness, drama. But big no. We don't do that. I was just asked if I'd ever seen Better Call Saul, and the answer to that is yes. Do I like it? Yeah. I mean, everybody loves Saul Goodman. I mean, he's freaking awesome. But what do I like about Saul? I don't like his persona. I don't like the fact that he doesn't just come off as sleazy. He is sleazy. But he's also hilarious in what he does, and clearly it's for entertainment value. But what I do like about Saul, and kind of putting it in the context of legal practice, is that Saul found himself in a position where he had to create a practice out of whole cloth with very little help. In the legal field, I think any attorney will tell you this. You can get a long way based on connections. You can get a long way based on your family connections. If your father or your uncle is a partner in a large firm, or even in their own practice, it takes a lot of the pressure off in law school to do well. And it also takes a lot of pressure off once you actually get into practice to find clients, because, hey, you've got someone with an established practice that is going to more or less make sure you're taken care of as long as you do the work. Saul was not that way. I mean, Saul had connections, but all those connections denied him. So Saul was kind of left to fend for himself, and what you get is a result of Saul being left to fend for himself. And having gone through this myself, having gone from, literally a laptop that I had in law school, a printer from Staples, and a pack of paper on day one, and just me, to where we are now. And I'm not saying that in a bragging sense. I've been very blessed. But to see that progression and to go through that helps me to identify with what Saul's struggling with. Saul's just trying to make it, and he does it his own way. And that's what I like about that show, is that you've got somebody who's making their own path and competing with people who are being propped up. His peers are being propped up by their family relationships, and Saul is competing with them and beating them at their own game, based upon basically his just will to win, at least in the movie. Obviously that's not how it works in real life. I mean, I firmly believe that, every blessing that I have has been a gift from God, and I'm a steward of it. I try to be. There was a time in my career where I took full credit for everything that was ever accomplished. And that I was quickly shown that that's not the proper attitude to have. So I have a much humbler attitude about it now. Anyways, Saul is just a movie. It's not real life, but it's a great testament to how a lot of lawyers, young lawyers especially, see the legal playing field. There's a proliferation right now of insurance defense lawyers, people that work at larger firms, leaving and going and setting up their own shop. That's an incredibly scary thing to do. A lot of these lawyers, they've never had, they've had jobs along the way, but their first real job is being an attorney. And they may have student debt from undergraduate school. They may have student debt from law school. Most people do. To work 3 to 5 years at a defense firm where they're making good money. They're paying their bills, and they're paying off their debt. That's, some people get upset about what they think attorneys make. Well, they've got a lot of debt that goes along with it, just like any other professional. They're giving up that security to basically go out into the wild and feed themselves. That's kind of what Saul did, except he didn't get the experience first. He used his street smarts to do it. And that's why you see a lot of young attorneys going out on their own and becoming plaintiff's attorneys, becoming personal injury attorneys, because there's this idea out there that is put out by lawyers that you can become wealthy and successful overnight. All it takes is the right case. The lightning will strike. It's not that simple. You got a lot of people vying for the attention of clients. A lot of people, both local and statewide. You've seen the inundation of TV and every medium of advertising with large firms, and then you've got smaller firms trying to chip out a niche, so to speak. It's for these people that are doing this. The first year or two, they may not make a dime. They're really just, think of yourself. You're dropped off in the middle of the jungle with a rifle and say, hey, feed yourself. You either do or you don't. And that's why you see people like Saul going to such extreme measures to make sure they're successful. Tell one on myself that I hoped would never resurface, but it's relevant to this conversation, and I'm trying to be honest here. I've done commercials in the past that I'm not proud of. I've done things to drum up clients that I'm not proud of. But when you're 3 years out of law school, and I only went in 3 years out then, I was probably maybe 1.5, 2, and you've got X amount of dollars in the bank, and you've got a wife and a kid, and you've taken it upon yourself to go out into the wilderness and feed them, you're going to do everything in your power to make sure that you do. So I did a series of commercials that I'm not proud of. I think I've spoken about it before. We'll settle your case for 20% is what the slogan was. And the reason it was 20% because the other guy in town was at 25. Race to the bottom, making sure we survive. That was the whole point of that one. And it was amazing the response that we received. We got a lot of clients in the door, Not clients I was proud of, not cases that I was proud to be associated with, but it were clients that I was making a living off of, so they were my clients. And I hated it. I hated walking into court knowing that I was representing this client for one reason, because I was going to make money off of them. Absolutely hated it. So I stopped doing it. There was been a period of, 6 to 8 years, something like that, where I did not advertise for personal injury cases at all. I wanted to rid myself of that stigma, rid myself of the stigma of being a personal injury lawyer, because personal injury lawyers as a whole deserve every joke ever made about them. There are some that are really good and do a great job, that are in it for the right reasons. And those guys and gals, I applaud them. But on the whole, they deserve every joke ever made about them. And I'm one of them, so hey, I'm throwing myself in there too. But I felt a call to get back into this because I saw what other lawyers were doing to their clients. I see the greed. I see people taking advantage of their clients. And I see the lack of care, the lack of work that some of these people are doing. And again, I'm not talking about all personal injury lawyers. There are some fine ones. And if I ever get into a case where I've got a conflict, I've got a ready list of people down here that I feel 100% confident sending somebody to. And I've also got a list of people that there's no way I would send anybody to ever. But anyways, decided to get back into it because I saw what was going on. But we're doing things differently this time. I am not negotiating my fee. I'm not. That's become incredibly popular. I was doing it in 2013 or 14, but now it's all the rage. I'm not, because a client is going to get what they pay for. When they hire us, they're going to get our full attention. They're going to get what they're paying for. A lawyer who's taking it at 20, 25%, whatever these cut rates are, they're taking in so many cases that there's no way they can actually pay attention to it. I tell a story about I built a porch, maybe, 6, 8 years ago. We had a nice little patio that we wanted to build a porch on top of and tie it into the roof. So we solicited a bunch of bids. I got 2 or 3 people come down, look at it. And we went with the guy that was the cheapest. We did. He quoted a good bit less than anybody else. And I knew this person's work. They were really good at doing other types of carpentry work. All right, I'd never seen a porch they'd built, but I'd seen plenty of other structures they'd built, and I felt confident that they would do a good job at it. Absolute mess. Absolute mess. They could not tie into our roof properly. They just couldn't do it. Ended up having to hire someone else to come back and fix what they had done, and it ended up costing 3 times more than the highest bid. There's 100 stories like that. Everybody's got a story like that. And it all comes back to this: you get what you pay for. If someone is coming to you at a ridiculously low rate, be suspicious of that. Be suspicious of that. We're not going to cut our rates, and we're not going to get involved in cases we're not proud of. If I tell my wife this, there was a period of time when we were doing those 25% or 20% commercials that I felt like a snake coming into church. I just felt sleazy and dirty. I couldn't wash it off me. It was so bad, but I'm just not going back to that. I'm just not going back to that. If I can't look myself in the mirror and say, hey, this is a valid case, we're pursuing a valid claim, then I'm not touching it. I'm just not touching it. I think I went way off topic there, but it felt right. Last topic, because I got to go do some work today. I don't get paid to do this. We did a video about, if it's about demands and giving insurance companies additional time to respond to demands. So if it's a 100-page demand, yeah, they get the time they get. But if it's a couple thousand or thousands of pages, a demand, then give them additional time. And one of the comments or questions, I'll just pose in the form of a question, was why doesn't the insurance company hire more people? So let's talk about that. In my experience, a single adjuster is assigned to a file. Okay. You don't want to have 4 people looking at the same demand because they're going to be all over the place. So one person is going to look at that file and go through it. That person is assigned however many cases that they're assigned. That one demand is one of tens or dozens that adjuster will encounter that given day, or that given month, excuse me. So the notion that you could somehow pull this apart and put 4 or 5 people and make them all responsible for it, it's just not practical. And honestly, you don't want that. As the plaintiff's attorney, I don't want that, because I don't want to have to explain to 4 different people who are going to have different questions. I'd rather have one point of contact where we can see eye to eye, or try to see eye to eye, as to what the actual facts are. There are things we can disagree about. There are things we must agree about. We don't have to agree about how much it's worth, but we have to agree on how much the bills are, how the accident happened, so on and so forth. I have to make sure that the adjuster understands all the things we must agree about, and then we can disagree about value. We can argue about that one, but I want to be arguing with one person, not 4, and I think that's practically sound. The next thing is, okay, well, insurance companies should hire more people. Well, I don't know if anyone listening has tried to hire lately. Everybody, no business is fully staffed right now. I talked to the district attorneys around here. I'm not going to name which circuit or anything like that, but on a consensus, they're all 3 to 5 lawyers short, with no hope, no immediate hope of filling those vacancies. Companies, I'm sure, are trying to hire. I'm sure they are. I'm sure the competition for competent, seasoned insurance adjusters is absolutely fierce right now. I'm sure they're letting them work from home, get them a benefits package. Hell, it wouldn't surprise me if they were putting in doggy daycares in the office. The competition is fierce, and I'm sure they're trying to hire right now. But I think the essence of the question asked, why don't they hire more people, really misses the point of why you give this additional time. I'm not going to give an insurance company additional time for their benefit. That's not why we're doing this. If I send a couple 1,000-page demand and I stand fast on the deadline, then if that insurance company cannot digest the information in a timely manner, they are left with no option but to reject my demand. That's probably not good for my client in most circumstances. Are there circumstances where you want the demand rejected? Heck yeah. But in most circumstances, that's not good for my client. It is better because if I say they reject it, then the next stop is litigation or sending another demand when they get another 30 days. Or I file a lawsuit, I have to get it filed, then they get 30 days after they're served. And then they're going to send discovery, and you go down this track that can take months or years. Or I can be reasonable. I can give the insurance company an extra 5, 10 days, whatever it may be. They get back with me. They accept it, great. If they reject it, at least I've given my client an opportunity to resolve that case in that 10 days. I've not taken that opportunity away from my client by basically being a jerk. All right, guys, hope you got some value out of that. If you're listening on a podcast, we'd really appreciate it if you'd leave us a review. If you're listening on a video platform, if you could like and share, we'd really appreciate it. Maybe share it with a friend that could use this information. Thank y'all.